Coming
Thank
at
you,
you.
Nikki.
You're welcome.
Thank you, Nikki.
You're welcome. Okay, so we're going to start today with the seller property questionnaire. This form is going to be updated in December, but they're really only adding 2 questions to it, so don't be too worried. In a normal transaction, meaning that everyone is alive and has lived in the property, a real estate transfer disclosure statement is a statutory required disclosure. And if the TDS is required, the SPQ goes along with it, the seller property questionnaire. So this form is mostly the second meatiest form in a transaction. It has the most information that a seller can give to a buyer. Just like the TDS, these forms need to be fully completed before they are given to the buyer.
Really?
They need to be dated and they need to be signed. This one is only the buyer and seller signatures, so that's a good thing. It's got to have the full address, assessor parcel number, which for whatever reason gets missed a lot, and it has to have the county. Remember, those TC ninjas are going to throw these forms back at you if you do not have those things filled out. Disclosure limitation. The following are representations made by the seller and are not the representations of the agents, if any. The disclosure statement is not a warranty of any kind by the seller or agents and is not a substitute for any inspection or warranties that the principals may wish to obtain. This disclosure is not intended to be part of the contract between the buyer and seller. Unless otherwise specified in writing, broker and any real estate licensee or other person working with or through broker has not verified information provided by the seller. A real estate broker is qualified to advise on real estate transactions. If seller or buyer desire legal advice, they should consult an attorney. Okay, the purpose of this form is to tell the buyer about known material or significant items affecting the value or desirability of the property, and to help eliminate misunderstandings about the condition of the property. The seller needs to answer based on actual knowledge and recollection at the time they filled out this form. Something that you do not consider material or significant may be perceived differently by a buyer. Think about what you would want to know if you were buying the property today. Read the questions carefully and take your time. If you do not understand how to answer a question or what to disclose or how to make a disclosure in response to a question, whether on this form or a TDS, you should consult a real estate attorney in California of your choosing. A broker cannot answer the questions for you or advise you on the legal sufficiency of any answer or disclosures you provide. Note to buyer, purpose, to give you more information. And once again, we have the words known material or significant items affecting the value or desirability of the property and to help eliminate misunderstandings. Buyers should consider that something that may be material significant to you may not be perceived the same way by the seller. If something is important to you, be sure to put your concerns and questions in writing on the car form BMI. I can honestly say in my entire 16 years doing this job, I've never had somebody submit a BMI. Usually if a buyer has questions, they're forwarded in an email and then the seller can answer that email. Of course, the emails go through the agents. Sellers can only disclose what they actually know. That's a big thing, guys. If the seller didn't know about it, they're not going to disclose it. So if it's something, say, underneath the house that the inspector finds, when the seller filled out the form, they didn't know what was going on underneath the house. Okay? Seller may not know about all material or significant items. Seller disclosures are not a substitute for a buyer's own investigation, judgments, or common sense. seller awareness. For each statement below, answer the question, are you, as the seller, aware of? By checking yes or no. If they're not aware of it or they don't know, the answer is no. Explain any yes answers in the space provided or attach additional comments and check section 18. Every TC I know and work with, including myself, will send this form back to you if a seller answers yes and does not explain. Their yes is required. If I do a paper packet of disclosures for you, I actually have a stamp that I put on a sticky note and stamp for this in the TDS that says, all yes answers require an explanation. So we're going to go to number 5, statutorily or contractually required. So statutorily means state required. 5A through K, these are the exact same questions that are on the exempt seller disclosure, which is required on a probate or a successor trustee situation, okay? So A, 5A, within the last 3 years, the death of an occupant on the property. Okay, law says 3 years. Guys, if your seller knows that somebody died on the property, they just need to say somebody died on the property, even if it's past the 3 years, because if you don't tell them, the neighbors definitely will. And like I said before in the class, surprise buyers tend to be angry buyers. So if someone has passed away on the property, the seller should write it there. And if it's natural causes, you can say natural causes. Okay, if it's not natural causes, definitely explain. 5B, an order from a governmental health official identifying the property as being contaminated by methamphetamine. Okay, so if methamphetamine is being sold on the property, there will be an order from the police and the court that it has been contaminated, and I think hazmat needs to come out and clean it up. So if that has happened, the seller needs to check yes. C, the release of an illegal controlled substance on or beneath the property. The seller is aware, check yes, and write it down there. Whether the property is located in or adjacent to an industrial zone. In general, a zone or district allowing manufacturing, commercial, or airport uses. So pretty much most of those homes near the Long Beach airport should all be checking yes. Most of those homes near Boeing, or McDonnell Douglas, or whatever it's called now, I don't know off the top of my head, they should be checking yes. Okay. If it's in Azusa and they're right near the Anheuser-Busch, they should be checking yes. And they should explain, located within a mile of the Anheuser-Busch, or located within a mile of the Long Beach Airport, or located within a mile of John Wayne Airport. Whether the property is affected by a nuisance created by an industrial zone. Guys, it's a simple answer. We're in the flight path. You know, if somebody really wants the house, they'll still buy it. My grandma's house was right under the flight path. I love that house. I'd buy it today if I could. I don't care. And most buyers know and don't care. But to say it and then afterwards, all of a sudden they have, they're right under the flight path, they're going to be upset. Whether the property is located within 1 mile of a former federal or state ordinance location. In general, an area once used for military training purposes that may contain potentially explosive munitions. Anybody know of an area like this? I do. It's that one that's right off of Westminster and Bolsa Chica. So, I'm pretty sure Leisure World is located within 1 mile. So that is a yes answer. For those of you on this call that have done files for years, I bet you can tell me that there's a lot of people that answered no to every one of these questions that you're thinking now probably should have been a yes. Whether the property is a condominium or located in a planned unit development or other common interest subdivision. Okay, this is a yes. I know it's dumb. Just put property is governed by an HOA. Property is covered, a condo governed by an HOA. One of the reasons this question is here, because most people, yes, are going to know it's an HOA, but there are some communities that are older that you aren't aware are a planned unit development. And that's why this question is here, because that is a material fact. Because there'll be taxes or there'll be payments for the roads, for the sidewalks, for the parks. Okay. H, insurance claims affecting the property within the past 5 years. Clients really need to think about this because lenders check the insurance claims filed, and if your seller says no and then the lender comes back to the buyer and says, oh, well, there's all these insurance claims, could be an issue. And I have had it where there were significant insurance claims and the buyer couldn't find insurance to cover their property. So make sure that your seller discloses this. If it's a little over 5 years, just disclose it. If it's an insurance claim, the insurance fixed it. So it's not a problem. Matters affecting title of the property. Any liens, any easements, or can't think of the other word right now. But just let people know. Material facts or defects affecting the property not otherwise disclosed to the buyer. Plumbing fixtures on the property that are non-compliant plumbing fixtures as defined by the Civil Code. Okay, so per the Civil Code, every home in California is supposed to have low flow toilets, low flow water showers. However, in Long Beach, in Lakewood, in Orange County, this is not a point of sale requirement. You can close escrow without the seller having to update those things. In the city of Los Angeles, they have a water cert that needs to be filled out, and it's a retrofit. You know that part in the contract, it's 72 III, talks about retrofit requirements. That is the retrofit requirement. Okay. So just if they're not compliant, they're not compliant. Just let people know. If any question is answered yes, they have all this area right here to explain. If it doesn't fit, they can check this and just do it on a Word document and have the buyer and the seller sign it. Any questions regarding that? Okay. Number 6, repairs and alterations. Any alterations, modifications, replacements, improvements, remodeling, or material repairs on the property, including those resulting from home warranty claims. Yes or no? Anything that they've done to the property, they need to list here. When I have a listing, I usually ask my sellers to write a list of all upgrades that they have done to the property, and we attach that to this disclosure. Any alterations, modifications, replacements, improvements, remodeling, material repairs to the property done for the purpose of energy or water efficiency improvements or renewable energy. Okay, if they've got solar panels, If they've got low flow toilets, if they've got low flow showers, that would be a yes. Ongoing or reoccurring maintenance on the property. They didn't used to have this lovely little example here. Drain or sewer clean out, tree or pest control service. Yes or no? Any part of the property being painted within the past 12 months? Yes or no? The yes would be what was painted? The outside, the inside, the kitchen, just the bathrooms? E, whether the property was built before 1978. Yes or no? Okay. If they answer yes here, they're going to answer A and B. If the answer here is the property was built in 2010, they don't need to answer these questions. There's no lead-based paint on the property. If it was built in 1960, answer is yes. If yes, were any renovations, sanding, cutting, demolition of lead-based paint services started or completed? Yes, they were. Or no, they weren't. If yes to this question above, were such renovations done in compliance with the EPA lead-based paint removal rule? Yes or no? Most painters have taken or they've gotten that certification about the renovation and what to do with the lead-based paint and how to do it and what to wear and all that stuff. So if these questions are yes, explain them down there. Okay. Number 7, structural systems and appliances. Defects in any of the following, including defects that have been repaired: heating, air conditioning, electrical, plumbing, including the presence of polybutylene pipes, water, sewer waste, disposal or septic system, sump pumps, well, roofs, gutters, chimney, fireplace, foundation, crawl space, attic, soil, grading, drainage, retaining walls, interior or exterior doors, windows, walls, ceilings, floors, and appliances. That's a big list. If there have been any problems with any of those things, the seller needs to say yes and say what it was. And they just say it's been repaired, if it's been repaired. The leasing of any of the following on or serving the property: solar system, water softener system, water purifier system, alarm system, or propane tank. This is a big one. If it is a yes, buyers need to know, because a lot of times the buyers need to be approved to take over that system if it's leased. An alternative septic system on or serving the property? Yes or no? Big thing, guys, about septic systems or wells. Septic systems need to be inspected, and sometimes they need to be cleaned out, and there is a certification. With wells, they need to test the water, so it's a big thing. We don't have them around here, but they are, let's say, Inland Empire has septic systems. A lot of them do. You need to know this before the property goes into escrow. Disaster relief, insurance or civil settlement. Financial relief or assistance, insurance or settlement sought or received from any federal, state, local, or private agency, insurer, or private party by past or present owners of the property due to any actual or alleged damage to the property arising from a flood, earthquake, fire, or other disaster or occurrence or defect, whether or not any money received was actually used to make repairs. So that Alquist Prio earthquake that happened in the valley, most of those homes will be answering yes to this. Any of the homes that have had a flood would be answering yes to this. The homes in Irvine that were affected by the fires would be answering yes to this. And they would be explaining it. Water-related and mold issues. Water intrusion into any part of any physical structure on the property. Leaks from or in any appliance, pipe, slab, or roof. standing water, drainage, flooding, underground water, moisture, water-related soil setting or slippage on or affecting the property. So guys, this would include if when it rains, there's an area of the patio or the garden where water sits for a really long time. This would include any kind of leak. Say yes and describe it. Any problem with or infestation of mold, mildew, fungus, or spores, past or present on or affecting the property. Even if there was mold and it was remediated, check yes and send those remediation papers over to the buyers. Rivers, streams, flood channels, underground springs, high water table, floods or tides on or affecting the property or neighborhood. Yes or no. I know some of those houses on the north side of the pier, I think it's the south side of the pier in Seal Beach, they had a problem a while back with the water coming all the way up to the seawall. So that would be a yes. Number 10, animals and pests on the property. A, pets on or in the property. Yes or no? I know you all think that if we went to the property and we saw the cat, when we looked at it, do we really need to explain what we have? Yes, you do. And my biggest favorite example for this is I hate snakes. Hate them with a passion. I will never knowingly buy a house that has a snake because I will always be afraid that there's a snake in the wall and it's going to have babies and they're all going to come out. If I bought a house and somebody did not tell me that there were snakes on the property and then I found out later, that would probably be something that we'd be going to mediation about. So the answer is yes. I have a cockatoo. Yes. I have a Tibetan Mastiff. Yes, I have a Golden Retriever. Yes, I have 10 cats. As long as the people know, it's not a problem. Problems with livestock, wildlife, insects, or pests on or in the property. If your client has problems with coyotes, they can check yes. If they have problems with spiders, they could check yes. They could say yes and just say that we have pest control come once a month. Past or present odors, urine, feces, discoloration, stains, spots, or damage in the property due to any of the above. This is a pretty big one, and the reason why is I was on a transaction where both agents in their AVIDs noted that there was a distinct odor in the property. The sellers had noted that there was a urine smell. When the buyers bought the property, they ended up having to take up the flooring and having a pretty expensive treatment done to the subflooring to get rid of the urine smell. And when they tried to say that they did not know about it, and we looked at all the disclosures, it was distinctly noted in all of the disclosures. So it's a good thing to note these things. Past or present treatment or eradication of pests or odors or repair of damage due to any of the above. You know, if they had a puppy and it peed in the same place every time and they had to take up the carpet, just say that. Things happen. 11, boundaries, access and property use by others. Surveys, easements, encroachments, or boundary disputes. If they're fighting with their neighbors over the fence, absolutely say yes. This happens more times than you think, and I have been on many a file where that is going on. Use or access to the property or any part of it by anyone other than you, with or without permission for any purpose, including but not limited to using or maintaining roads, driveways, or other forms of ingress or egress, or other travel or drainage. Sometimes the city may need to go across your property to do something. That would be one example of that. Sometimes you share driveways. Use of any neighboring property by you. So the condo next door to mine, he has all the main power switches for all of the condos on our side of the building. So if all your power goes out, you have to go to my neighbor to get him to flip the switch for you. That is something I'd probably need to disclose. Landscaping, pool, and spa. Couple notes on this. If this is a condo, the point of this disclosure is to talk about the actual property. So if I'm talking about my condo, even though my condo has a pool, condo association has a pool and a spa, my actual property part does not. So the answer would be no. So disease or infestation affecting trees, plants, or vegetation on or near the property, that could be a yes if you're in a condo, if all the trees got diseased. Operational sprinklers on the property. In my case, it would be a yes because on my patio, I have automatic sprinklers. But if it's a condo where they don't have any sprinklers, the answer is no. If it's a home without any sprinklers, the answer is no. If the answer is yes, they have to check whether they're automatic or manual. If the answer is yes, are there any areas with trees, plants, or vegetation that are not covered by the sprinkler system? Yes or no. Sometimes it's as simple as, yes, we have sprinklers, but they don't get that tree in the back corner. A pool heater on the property. If it's a condo and there's an association pool, the answer is no. If it's a home with a pool, the answer is yes. Is the pool heater operational? Yes or no. Spa heater on the property? Yes or no. Is it operational? Yes or no. Past or present defects, leaks, cracks, repairs, or other problems with the sprinklers, pool, spa, waterfall, pond, stream, drainage, or other water-related decor, including any ancillary equipment, including pumps, filters, heaters, and cleaning systems, even if repaired. Yes or no, and explain. Okay. I can't see anybody's faces right now. They all went away. So I can't tell if you guys are following me or not. So number 13, even if you're in a condo, not all of these questions are going to be a yes, but one of them will. Are you, the seller, aware of any pending or proposed dues increases, special assessments, rule changes, insurance availability issues, or litigation by or against, or fines or violations issued by a homeowner association or architectural committee affecting the property? In this case, they mean the property, including the whole condominium property. So if your seller knows if there's going to be a special assessment coming up, they would check yes or no. Most people, this one could almost, is a lot of times no. B, any declaration of restrictions or architectural committee that has authority over improvements made onto or to the property. CC&Rs are part of HOA docs. Those are codes, covenants, and restrictions. Okay, yes. I don't know many HOAs or condo associations that don't have restrictions. I also don't know of many condos that don't have an architectural committee that can tell you what kind of door or windows or what you can put on your patio. So this question 13B is almost always a yes if it's a condo. 13C, any improvements made on or to the property without the required approval of an architectural committee or inconsistent with any declaration of restrictions or architectural committee requirement. In my case, this would be yes, because I added to my fence, but I did get architectural committee approval. Okay, questions?
We're looking good, Nikki. Nothing in chat.
Okay. Note, I would say 75% of the time that I'm on a condo transaction, all of these answers are no. So just check that. If you're selling a condo, just check that. 14, title ownership, liens and legal claims. Any other person or entity on title other than the sellers signing this form. Okay, make sure you guys, please, please, please order those property profiles before or the day you get your listing. Title gets them to you within like a couple hours. That'll let you know whether somebody else is on title. I have absolutely done listings where, oh, it actually turns out the person that thinks they can sell the property is not on title. Or, oh, actually, the three brothers are on title. Or, oh, yes, your wife is on title. Leases, options, or claims affecting or relating to title or use of the property. Past, present, pending, or threatened lawsuits, settlements, mediations, arbitrations, tax liens, mechanics liens, notice of default, bankruptcy, or other court filings or government hearings affecting or relating to the property, homeowner association, or neighborhood. If you're in a condo and somebody's doing it, the answer would be yes here. Okay. Any private, I think there's a, I can't remember where the neighborhood is, but the builder that built all the buildings, the entire neighborhood went and sued him for some sort of defect in the homes, and they all won. So it isn't just condos that this would answer yes. Any private transfer fees triggered by the sale of the property in favor of private parties, charitable organizations, interest-based groups, or any person or entity. Remember, if your seller doesn't know the answer is still no. Are they aware of it? If they're not aware of it, the answer is no. Because I'm going to remind you guys, if after the disclosures are received, you get something from escrow that talks about this, or you get the property inspection that talks about something the seller said yes or no to, that fact has now been disclosed to everybody. So the seller doesn't need to change. And at the front of this, top of this form, it says the seller may not be aware of things. Any PACE lien, such as a HERO or SEP or other lien on your property, securing a loan to pay for an alteration, modification, replacement, improvement, remodel, or material repair of the property. So a lot of people I know got HERO loans to do their windows or roofs or whatever, and those actually were liens. So even if you got the money, just say you got the money. The cost of any alteration, modification, replacement, improvement, remodel, or material repair of the property being paid by an assessment on the property tax bill. Yes or no? Okay, are you aware of number 15, in the neighborhood? Neighborhood noise, nuisance, or other problems from sources such as, but not limited to, the following: neighbors, traffic, parking congestion, airplanes, trains, light rail, subway, trucks, freeways, buses, schools, parks, refuse storage or landfill processing, agricultural operations, business, odor, recreational facilities, restaurants, entertainment complexes or facilities, parades, sporting events, fairs, neighborhood parties, litter, construction, air conditioning, equipment, air compressors, generators, pool equipment or plants, underground pipelines, cell phone towers, high voltage transmission lines. Surprisingly enough, you guys, I get a lot of no's on this question. Okay, if it's a house in Belmont Shore, there's absolutely parking issues. There's restaurants. I've gotten this where, what was the one I just was thinking of? High voltage transmission lines. There's a whole bunch of houses over there off of, oh goodness sakes, Palo Verde, I think, the neighborhoods over there that have the transmission lines in like the background. I've had yes, no answers on those. When you're doing these disclosures with your sellers, I want you to think about what's going on around there and, just talk to them about it. If they live right near the Naval Weapons Station, there's tons of coyotes in there. Might be something that they want to note. So I hope as you're going along, you can see places where people will think it's a super simple question, but there's actually a little more thought that needs to go into this form. Governmental, ongoing or contemplated imminent domain, condemnation, annexation, or change in zoning or general plan that applies to or could affect the property. In Orange County, and I think somewhere else right now, they're doing tons of work on the freeways where I know they've pushed people's backyards. In fact, there's one part of the freeway where you can actually see that they've pushed the wall back so far, half of some kid's treehouse is on the side that the government is now taking. Existence or pendency of any rent control? Methinks Long Beach would be a yes. Occupancy restrictions, improvement restrictions, or retrofit requirements that apply to or could affect the property. If it's a Los Angeles property, this answer, you guys, would be yes. Existing or contemplated building or use moratoria that apply or could affect the property. Current or proposed bonds, assessments, or fees that do not appear on the property tax bill that could affect the property. Proposed construction, reconfiguration, or closure of nearby government facilities or amenities such as schools, parks, roadways, traffic signals. If your home is in Huntington Beach that you're selling, this is going to be a big, huge yes, because basically every bridge in Huntington Beach is having construction. I don't know if you could tell, but I'm a little bitter about that. Existing or proposed government requirements affecting the property, that tall grass, brush, or other vegetation be cleared, that restrict tree or other landscaping, planting, removal, or cutting, or that flammable materials be removed. Flammable materials being removed, that's part of that defensible space on that fire hardening defensible space advisory. Any protected habitat for plants, trees, animals, or insects that apply to or could affect the property. Gosh, you guys, if that red tree frog is a protected tree frog and it's on your property, that should be a yes. This one, a lot of times in Long Beach, is a no. Whether the property is historically designated or falls within an existing or proposed historic district, there is a huge amount of neighborhoods in Long Beach that are in historic districts. So if your property is in Long Beach, check and make sure. There is a supplement that we use for Long Beach properties where you can check the property that's in the historic district. Any water surcharges or penalties being imposed by a public or private water supplier, agency, utility, or restrictions or prohibitions on wells or other groundwater supplies. In Glendora, they get fined if they use too much water. So that would be a yes. Number 17, other. Are you, the seller, aware of reports, inspections, disclosures, warranties, maintenance recommendations, estimates, studies, surveys, or other documents pertaining to the condition or repair of the property, or any improvement on this property in the past, now, or proposed, or easements, encroachments, or boundary disputes affecting the property, whether oral or in writing, whether you're yelling at your neighbor across the fence, or whether you have it in writing, whether or not provided to the seller. If yes, provide any documents in your possession. Any occupant of the property smoking any substance on or in the property. This is a yes or no question. Guys, in December, this is going to change to smoking or vaping. Okay. Any past or present known material facts or other significant items affecting the value, desirability of the property not otherwise disclosed to the buyer. Yes or no. If checked, if you have a list that you've attached to this, or addendum, check this so that the buyer knows. Seller signs and dates, buyer signs and dates. And that is probably the first or second most important form. We are at 11:45, so let's bang through the rest of these. Parking and storage disclosure. So this is it's not a car required form, but it is a Coldwell Banker required form. And let's see, I'll pull it up right now. This is for if it's a condo. And basically what it does is at the top, it says the seller does or does not have a parking space and what number it is. The seller does have a storage space or does not have a storage space. So basically this form is just telling the buyer in writing from the seller the parking space number or the storage space number, or if they don't have either of those. Okay. Buyer's Homeowner Association advisory form. So guys, gals, guys, everyone, that HOA packet is huge. It's usually at least a ream of paper. I'm not an expert on HOA docs. I'm pretty sure you guys aren't experts on HOA docs. Even if you're on an HOA association, what this form does is it tells the buyer what important things they should be looking for. Okay? Coldwell Banker Coastal Alliance wants this given anytime a buyer is going to receive HOA documents. This is an important form. I really like this form. Read this form. Talk to your buyers about this form. Okay, the next form we're going to talk about is the trust advisory. This is an advisory. It's not a disclosure. It's not an addendum. It's just an advisory. It is not a CAR required form. Coldwell Banker Coastal Alliance does not want this form on every transaction that has a trust. We want this on transactions where the successor trustee is selling the property. The reason we only want it on those types of transactions is because, hold on, it's loading. What this form does is it tells the buyer when a property is an exempt property. And it tells them what they have to comply with and what they do not have to comply with. So if this is a successor trustee, they need to tell known material facts. They need to do hazard zones, which we get with the natural hazard report. They do need to install smoke detectors. The water heater needs to be based and strapped. They need to say and give the lead-based paint disclosure. Carbon monoxide devices need to come with the property. Water conserving plumbing fixtures, it's not exempt, but it's still not a point of sale requirement. Tax withholding. Successor trustees are not exempt from withholding tax. Megan's Law database. It's not exempt from that. It's in all the purchase contracts. We don't need to give that extra disclosure. However, the seller may be exempt from the TDS and the SPQ. Other consideration, the sale's not exempt from an AVID, probate and trust sales. You are not exempt from your AVID, and in fact, if the seller is not selling at a TDS or an SPQ, your AVID should be really good because it is really the only thing that is paying passed on. Okay, the sellers sign it, the broker signs it, meaning the listing agent, and the buyer signs it. Questions on that? If I hold title to my property in the Niki Conrad Trust, I'm not going to do a trust advisory. If I inherited property from the Kirkland family trust and I'm a successor trustee and my grandmother is no longer alive, then I would give the trust advisory. Okay. Seller affidavit and non-foreign status. We talked about that a while back. There is an exemption to whether the seller has to provide that, and that is if the buyer, if the property is under $300,000, you don't need to do the FIRPTA. And somebody is going to occupy, somebody or their family is going to occupy it. If the property is under $300,000 and it's an investor property, there is no withholding tax. So if the buyer is buying a property under $300,000, you need to provide the buyer affidavit to the seller. This is what it looks like. The sales price does not exceed $300,000. I'm acquiring the real property for use as a residence. I have definite plans that I or a member of my family will reside in it for at least 50% of the number of days it will be in use during the first 2 12-month periods. The buyer is making this affidavit to establish an exemption from withholding a portion of the sales price. Okay. Affiliated business disclosure. This is required for all the properties that you sell and you use All Coast Escrow. Let me pull up the affiliated. A lot of companies have affiliated business disclosures. Of course, I can't find the one that I want. There we go. Okay. Affiliated business arrangement disclosure. Coastal Alliance Holding Incorporated. We are affiliated with All Coast Escrow. All Coast Escrow is not a broker-owned escrow. Just a couple of the owners of Coldwell Banker Coastal Alliance are also owners in All Coast Escrow. All Coast Escrow is governed by the Department, I think, of Corporations. So, what is it, Chuck? I can't think.
Business oversight?
Yes, business oversight.
Gotcha.
They are not broker owned. That is important, you guys. Okay, what else? Did you see that one? Were you able to see that disclosure?
Yes.
Yes, okay. The other disclosure, the next one I think on my list is, I've got so many things open. Orange County. Okay, can you see the Orange County Realtors local area disclosure?
Yes.
All right. So if your property is in Orange County, you really need to give out this disclosure. There is a whole lot of stuff going on. Construction of an additional northbound and southbound lane on the 405 between the 73 and the 605. Construction of the carpool lane on the I-5, widening of the northbound 57, the 91, the 241. So this has got the John Wayne Airport, desalinization plants, landfills, aircraft noise, San Onofre, those Orange County wildlife, Orange County entertainment venues, new and proposed developments. If your property is in Orange County, give this disclosure. The one great thing about this is it's got these blue links. So if the buyer does have any questions, they can click on the link and it'll take them to that place. This is a good disclosure. Finally, the natural hazard report. Let's see. Of course, that's not. Okay, this right here is the natural hazard report, including environmental. We at Coldwell Banker Coastal Alliance want environmental on all NHD reports. Okay, most of them have maps, some of them don't. This is the most important page. It's the NHD signature page. Right here in this little area, it tells you all the zones. Special flood hazard zone, area of potential flooding, a very high fire hazard zone, a wildland area that may contain substantial forest fires, risks, and hazards, an earthquake fault zone, yes, a seismic hazard zone, yes, okay. Chat. Can I put, yes, I can put the OC disclosure in the chat. Give me 1 second. Okay, the NHC report then goes on to explain in more detail, and then it explains in even more detail. So if you guys have questions regarding, you know, the seismic hazard mapping, earthquake fault zone, it talks about geological zones, fault zones, fire, tsunami zones. My house is in a tsunami zone. Sea level rise, other hazards, geotechnical hazards, floodplains. There is also a part in the natural hazard disclosures. I'm coming to it. Right on. Okay, that's all the environmental stuff. Special tax assessment. This talks about special tax assessments in the specific property. There is also a breakdown of the tax bill. Okay, if you ever have any questions, point the clients to this area. Okay, really important. Okay, let me go back at that Orange County disclosure. Any questions, you guys? I kind of ran through that last bit pretty fast. But we have now gone through all of the disclosures required by Coldwell Banker Coastal Alliance, which for the most part coincide with all of the disclosure requirements for CAR. Where's my downloads? There we go. Okay, I uploaded the Orange County local area disclosure. Quick side note, a lot of brokers are sending out that a local area disclosure for Los Angeles County. The majority of them, guys, do not cover Long Beach or Lakewood. There's really nothing in them that goes with our county. So I'd be a little wary about providing that to your clients just because, you know, Long Beach has nothing to do with Malibu. Okay. So just look at them. But the Orange County disclosure, I don't know many properties in Orange County that are not near or affected by the freeway stuff right now.
Or even the airport stuff.
Right, right. Okay. Okay, so real quick, I'm just going to touch on this. In December, we're going to lose the probate purchase agreement, and we're going to lose the mobile home purchase agreement. Those will now have addendums that will be attached to the contract. So the regular RPA is going to be used in those cases, and it's going to have a mobile home addendum and or a probate addendum. If you saw my post, I think there's something like 79 forms are being revised. Sometimes, like in the case of the SPQ, it's just they're adding 2 questions. The lead-based paint at this time is called the FLD, and they're actually just changing the acronym. So just be aware, there are going to be a lot of interesting changes in December, but the required disclosures are not changing. Okay. I think that's it.
Well, very good, Nikki. Well, thank you again so much. I mean, you always do a great presentation, and like Nikki mentioned, we're going to be having you know, a lot of changes to the forms coming up, but we will be doing training that we're all mapping that out based on, you know, the outcome of us being up to speed with everything that needs to happen with those, so that we can convey that information out to you guys. And but so you'll be seeing that coming up starting in November and through December. And again, Nikki, thank you so much. If you guys have any follow-up questions or anything, don't hesitate to reach out to her or me or Nicole, and we'll be happy to help you. So thank you, everyone.
And real quick, just so you know, we were saying October for the purchase contract, but I took my 8-hour class and I want to take the 8-hour class again, and that's not till December 8th or October 18th. So that's why we're pushing the new contract classes to November. So you guys all have a great day, and thank you so much.
Thank you.
Thank you, Nikki.